Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Lope TV. I hope this series has been helping y'all understand this stuff a lot better, and I hope the commentary within this series on this particular subject is helping y'all also. Before I begin, y'all already know the routine. If you haven't already, please go ahead and hit that like, subscription button, and turn that notification bell on. And we will go ahead and pick up where we left off, but I'm gonna give y'all a second to do that first. Okay, so I think we were on page 27. We finished this page, and so I think we're right here right now. This is page 27. um, Before I begin reading this one more time, I just want to say this. If y'all don't like the way that I read it, or if I'm stuttering too much, or rereading sentences too much, or whatever, just pause it, you know, and then you could just read it that way. Also, I have already sent out a few emails in regards to people asking about copies of the book. I've already sent y'all copies. I hope y'all got them. So let's go ahead and start. My legal senses tend to caress the notion that a father could release his right to the custody and control of his child to the child's mother. However, we know that the case law makes clear that the parental power can only be lost by releasing parental power to a third person by voluntary contract. If my caressing of such thoughts turns out to be true, then this truth in itself will create a precedence of a historic precedence already presented. Out of historic precedents that's already presented. You gotta go to that phone again, ringing again. Notifications. However, I have prepared this bonus section as a warning for fathers to be mindful of any verbiage or actions of releasing the right to the custody and control of their child, not only to a third person, but to the mother. However, I must state that in any instance in which a father would even release such rights creates the inference that such father is the type undeserving of custody, but deserving of payments for support, which can be easily proven by a single mother struggling because of his relinquishment. However, I am all too familiar with the obscurity of the family court industry and how this voluntary release of parental power can be used as a weapon against fathers to trap them into contracts. Heed my warning. I imagine the father who is overseas fighting for his country, or what left of it. For instance, the man is married or unwed and has left his children with his wife, girlfriend, or grandparents for an overseas military mission and has been absent for months. He has to leave his children in someone else's care. Could doing so in, could doing so could his doing so, including his absence, truly be abandonment, which his absence is involuntary, or in other words, required under penalty of law? However, I am almost assured of his success in family court in situations fitting within this series, so long as he is providing maintenance to his child while overseas. However, could this act become a trick to state that an irrevocable contract was made to pay child support to the mother? That's a good argument, but I don't think that argument would work. With these new laws in play, they may come forth quickly in family law. I foresee a future where attorneys absolutely encourage fathers, or even society becomes aware of the importance of written contracts to ensure that parental power or is never relinquished, and even if reasonable private maintenance in any absence, it is only for situations where a father's absence is involuntary and that the contract becomes void on his return or custody of child. I agree with that. That's actually something that I would have said. I would have made sure that that was expressly mentioned in the contract, something along those lines. Take the case of Towns End versus Warren, for instance, which was a case about a father who released parental power but later wanted to exercise custody of his child. The GA Supreme Court disagreed in saying that the father, he, delivered the custody and control of the child to them. There was evidence that petitioner turned the child over to the defendants a few days after the death of his wife. Oh boy, 1896. So in addition, take the case of Southern Railway Company versus Flemister, which was a case about a father who sued a railroad company for the value of the services and labor of his child for the alleged negligent homicide of his daughter. The court reversed a court's finding the father in stating that having released all parental control, and all the right to the services of the child, the father necessarily lost the right to sue for and recover the value of such services. I see. We now move on to Series 2. Series 2. This Series 2 involves Fact 1, circumstances where there is no child support order or order of custody. Fact 2 involves circumstances where there is a custody order and child support order, but the mother requests Title 4D services. In these Fact 1 situations, I'm almost assured that in the near future, the state's legal team will almost undoubtedly propose, that any agencies who receive any such responsive notices from the so-called non-custodial parents who contest the agency's enforcement as applied to those parents' cases, further communications and enforcement with that parent until further notice. Boy, I'm already tired. Time for me a nap already. I make this assertion because these legal teams may find it wise to allow situations in Fact 1. I'm not going to answer that. My phone is ringing, y'all, but I'm not going to answer. Sorry about that. A court to first adjudicate parental power before asserting its enforcement hand as an administrative agency because of the legal implications and case precedents that may arise from its failure to do so. These fathers should respond to any Title 4D notices with the template below shown notice to single and separate Title 4D agency, notice to state managing said agency, notice to recipients of violation and infringement of privacy, pecuniary property, and economic interests of the undersigned. Okay. I kind of see where they're going with that, but I would need to read it to see. I'm going to need them to substantiate it. After such an agency refuses to cease its enforcement efforts or fail to schedule a hearing based on your requested relief in the template, if non-payment contempt is filed, whereby jurisdiction cannot be challenged against you after services of said notice, it would be wise to utilize an injunction and declaratory relief provided as a template below. Amend these templates below to conform it to your case-specific situation. Seek help. Challenge all enforcement actions under Title 4D as applied to you. In these Fact 2 situations, I am almost assured that in the near future, the state's legal team will most likely propose to all agencies who receive any such responsive notices from the so-called from the so-called non-custodial parents who contest the agency's enforcement as applied to those parents, that although among their esoteric ranks, they know that their enforcement actions may be unlawful. I'm gonna say unlawful because that's essentially what unconstitutional means. Unconstitutional means unlawful. For the sake of the state's purse, such agencies will be required to continue such enforcement. However, depending on the circumstances and the length of the time the child support case has been active, because the longer a child support case has been active, the harder it may be to prove what were the circumstances at the initial child support order due to the passage of time. Series 3. Series 3 involves circumstances where a father who has been adjudicated the father and has a court order for visitation, supervised visitation, or joint custody, not to be confused with legal custody, meaning the right to make decisions on the child's behalf. That's a good. I'm glad that the author is pointing that out because I didn't even know that joint custody and legal custody were two different species of custody. I did not know that. But I'm glad that the author is pointing that out. Thank you for that. And who has previously been ordered to pay child support. I bring your attention to the chart below. Y'all know I'm not going to read the chart. I'm gonna stop, about 30 seconds, maybe let y'all read it, and then I'll come back to it. All right, I'm gonna go ahead and just go to the other page. The most significant question of the 21st century, which only hurting fathers can only dream of whether the questions is answered by the Supreme Court of the United States, is whether substantial due process is violated in custody proceedings if a court fails to give notice to the fathers who receive visitation privileges that property rights to the services and labor of their child are at stake. Damn, that is a good question. That is a great question. I think the answer to that question, it may have already been decided. It depends on what the court has already said in regards to substantial due process rights violations. But I think, if I'm not mistaken, because this is a fundamental right, I don't think fundamental rights can be waived implicitly. At least I don't. I don't think they can. I think they have to be knowingly, intelligently, and voluntarily waived, if I'm not mistaken, because that is a constitutionally protected right. Fundamental rights are essentially constitutionally protected rights, if I'm not mistaken. In other words, or in better terms, does it violate substantial due process for a lower court's failure to make a determination of whether a father's parental power has been lost through any fault of his own? In addition, does it also violate substantial due process for a lower court's failure to make a determination of whether a father is an absent parent within the meaning of Congress's rationale of Title 4D before ordering child support to be made? I would say yeah, because if the statute if that is a prerequisite element, meaning that it is something necessary that needs to be proved before they can do something else, meaning order child support, then I would say yes. I would. If the answer is yes, then essentially every single custody order in America will have no choice than to be overturned as a matter of law. I would agree with that. Consequently, all child support orders may then be considered null and void. Congress must legislate before such a happening. I don't think Congress need to legislate. I think it needs to be tried. I think somebody needs to raise this argument. Is it if it hasn't already been raised? I think someone needs to raise the argument and appeal it. You're going to have to appeal it through statutes, though. So everything is administrative, all the way up to the Supreme Court of the United States. All of them are administrative courts. They're acting in an administrative capacity, every single one of them. So I would, I think somebody's going to have to raise that argument, which is a good argument, by the way. And I don't know, what is it? A petition for writ of certiorari, I think. to see if you can get them to answer. It's discretionary. They're probably not going to answer it because they understand um, the potential outcome if they rule against it. They already know. That's why they tried to hide that Roe v. Wade overturning. Bonus. Does the best interest of the child violate the Constitution by treating property rights inferior to the paramount concern of the Constitution? By treating property rights inferior to the paramount concern of the Constitution. Let's see. Behold, for I have given you knowledge, because thou hast rejected knowledge, I will also reject thee. This chapter essentially picks up where we left off. It is well known that family courts are courts of limited jurisdiction. Y'all remember when I talked about that? Courts of limited jurisdiction? They're inferior courts, they're legislative courts, and courts of general jurisdiction are courts that can hear all types of cases. So in other words, inferior courts are courts of limited jurisdiction. They're created by statutes. Okay, courts of general jurisdiction are courts not created by the statutes. They are created by the sovereign people of the so-called state in which they reside. Okay, and they have pretty much unrestricted authority to a certain extent. The only one who can overrule these types of courts would be the people. The only one who can nullify everything in every branch of the government is the people. The people are a coordinate department of the government. It's like the people are God over the government, so to speak. You see what I mean? Because the people created the government, if that makes sense for y'all. Let's see. It is also known that when a trial court orders a form of custody, the best interest of the child is paramount. Let's see what they're making now. Let's see what kind of argument they're making right there. All custody proceedings in family courts, which are courts of limited jurisdiction, they're legislative courts, y'all. Legislative courts, statutory courts. I'm gonna pause this and let me show y'all something right quick. I'll be right back. Okay, this is a document that I drafted. I did some research on some case law for y'all. See where it says constitutional versus legislative courts, and these are cases. These will mostly be Alabama cases, but I think there may be a mixture of other um, state citations as well. So we're going to focus on what was being taught in the ebook, and that is courts of limited jurisdiction. So inferior courts, aka statutory courts, aka admiralty courts, aka civil law courts. Civil law means statutes and codes, y'all. Admiralty courts are civil law courts. Okay. The legislature has the power to vest in courts of statutory creation any of the powers or portions of jurisdiction of the chancery or circuit courts to be exercised concurrently. That means to be exercised together, if I'm not mistaken, or at the same time. Where a special authority in derogation of the common law is conferred by statute on a court of general jurisdiction, that means on a superior court. Okay, that means on a court created by the Constitution. So what they're saying is when a special authority in derogation of the common law is conferred by statute, that means when the legislature has authorized the people's court to hear and adjudicate some type of case via a statute, okay, that court of general jurisdiction, meaning that Supreme Court, that superior court, it becomes quad hoc an inferior or eliminate or limited court. And jurisdictional facts must be shown on the face of the proceedings because it is an inferior court. I did a video on this as well, just to let y'all know. This is something that I want to talk about a little later. I'll do it later in a review of one of Yusuf L's videos. In every constitution of Alabama, there has been a provision for inferior courts. Section 139, Constitution. The Constitution of 1901 made provisions for inferior courts instead of justice of the peace courts in certain circumstances. Section 168, that's in the Constitution. Okay, so let's go. I'm trying to. I'm not. I don't think I'm gonna read all of this because I don't want to get too far off point with it. Let me see. All right. Yeah, I'm probably gonna read. Once I think I made my point, I'm gonna stop. Put it like that. The division of courts recognized at common law was superior or courts of general jurisdiction. So what I'm trying to tell y'all is superior courts are synonymous with courts of general jurisdiction, and inferior courts is synonymous with courts of limited jurisdiction. And inferior are courts of limited jurisdiction. Superior courts, pay attention, y'all. Pay close attention. Superior courts derive much of their jurisdiction from the common law. Ain't no statutes in common law, y'all. Inferior courts derive their whole existence and jurisdiction from the statutes constituting them. Hence, nothing was intended to be without the jurisdiction of a superior court, whether of appellate or original jurisdiction, except what appeared to be so, and every presumption consistent with the record was indulged in favor of the regularity and validity of their judgments, while of inferior courts no intendment was made favorable to their jurisdiction, and a conformity of the law of their creation must have been disclosed by their records. Such was the only division of courts at common law into superior and inferior. It followed from the character of jurisdiction that courts exercise, and not from the subjection of the court to the appellate power of another tribunal. In the last sense, all courts of original jurisdiction are inferior to a court exercising over them appellate power. That makes sense. So let's see. I think that. Let me see. I think that was pretty good. Let me see. I think that was well. I'm gonna read. I'm gonna read this little part right here, and that'll be it. And then I get back to the book, y'all, because I'm trying to prove a point. I'm trying to substantiate or let y'all know the distinction between limited jurisdiction courts and general jurisdiction courts. That's what I'm trying to do. It has many times been declared that it is within the providence that is within the province of the legislature to establish inferior courts of concurrent jurisdiction with that of the circuit courts, and to provide for transfer of cases from the circuit court to such inferior court. Where are we? An inferior court within the meaning of Section 139 of the state of the Constitution of Alabama, basically, giving to the legislature the power to establish the same, is a court whose judgments or decrees. Notice they say judgments or decrees because there's two different things. Decrees, or if I'm not mistaken, decrees are done in courts of equity, and judgments, if I'm not mistaken, are done in courts of law. Is a court whose judgments or decrees may be reviewed by an appellate tribunal, whether that tribunal be the circuit court or other appellate court. And the legislature has the unquestioned power to vest in inferior courts of statutory creation any of the powers or portions of the or portions of the jurisdiction of the chancery court. Let me see. Of the chancery or circuit courts to be exercised concurrently with those courts. Hopefully that kind of helped y'all out, because there are two court systems that I mentioned. But let me get back to the book. I'll be right back, y'all. Okay, so let's get back to it. I'm going to start back right here. All custody proceedings in family courts are courts of limited jurisdiction. The child's best interests are paramount. This essentially asks another question. Does family courts does family courts disregard the rights of property as paramount? Property, father's right to the services and labor of the child, and other rights. Or does it simply not concern itself with it because the father has not invoked them? Now you know how. The protection to person and property is the paramount duty of government. I would agree with that, and shall be impartial and complete. Article 1, Section 1, Paragraph 2 contradicts paramount concern to be the best interest of the child. No person shall be denied the equal protection of the laws. GA Constitution, U.S. Constitution. How can the best interest of the child be paramount over the paramount duty of government? That's a damn good argument. It simply cannot when invoked properly, which the template on the last page teaches, which the template on the last page teaches, which is fathers make a constitutional as applied challenge to the usage of the best interest standard in their custody proceeding, or simply motion to displace the use of the best interest standard because constitutional issues are at play. The maxim of law: if one sleeps on his rights, he has none. Here are important terms to consider: substantial due process, notion protecting not only legal procedures but rights unrelated to legal procedure, equitable consideration, consideration for a contract based upon a moral duty instead of a legal one. Okay. Moral obligation, a duty which one owes and which he ought to perform, but which is not legally bound to fulfill. Legal obligation, one that can be enforced by the courts and are either created or based in the law of a state. The obligation of a parent to support a child has long been recognized in a majority of American jurisdictions as not only a moral obligation, but one that is legally enforceable. Mhm. It can only be legally enforceable if and when a father has abandoned his child and while refusing custody, refusing to provide maintenance. Privacy rights. If your property rights and fundamental rights are taken away unlawfully, it then becomes a violation of your privacy right. I agree with that. Because there has been no finding that the father is an absent parent in requesting the father to fill out Title 4D required child support guidelines, require the court to motion to determine if a father is an absent parent within the meaning of Title 4D, TANF, etc., as alleged in the template below. 2. Property rights. Right to the services and child, right to the services of the child and labor. Fundamental interests, pecuniary interests, and economic interests. Google Scholar, that's pretty good. They did their research on this shit. Fundamental rights, right to the religious and educational upbringing, custody, etc. See this visual learning graph below to assist you. A constitutional issue cannot be considered when asserted for the first time on appeal, but must be clearly raised in the trial court and distinctly ruled upon. There's the case. So you got to raise it. If you don't raise it, you waive it. I'm guessing. I don't see how. I don't know. I mean, that's what they rules. They must have changed it because I thought constitutional rights had to be waived expressly, intelligently, and voluntarily, if I'm not mistaken. Although this is a Georgia case law, it applies uniformly. Uniform means everywhere. That's true, by the way. With the fundamental interest we'll have just mentioned, we are asking the court to rule on the issue of custody based on the constitutional issues as applied to you, under strict scrutiny protection, not the best interest standard. The only thing a father is to know now is simply the only thing a father is to know now is simple court procedure. However, I have already done most of the work for you. In addition, learn about bypassing the traditional wait and out on appeal to follow their status quo in the event that a court decides they want to punish you for utilizing constitutional protections by making a deliberate erroneous order in retaliation for your assertions. However, as you will read, the court can either order joint custody or terminate child support. They will not be able to have their cake and eat it too. The genius of the common law. As long as a father can articulate his claims, you will be successful. Let's see. Okay, so this is the notice that they were talking about. Notice to single and separate. Title 4D agency notice to state management agency. Okay, so these are all notices to the administrative agencies, recipients, Secretary of State. Notice that they're sending all this shit to DC. So these people are getting federal funding for this shit. So if they're getting some type of federal funding, they're doing business. They have to have some type of contract. Excuse me. They have to have some type of contract with the corporation called the United States that's located exclusively in the District of Columbia. They doing business, but they're hiding behind these fucking names: State of, District of Columbia, Washington D.C. These are all corporate entities. Let's see. This is a notice. This is a notice and an open records FOIA request pursuant to state and federal statute. Such state FOIA record request is made below. Full name and title of caseworker on account number. Uh, Input your support account number, full name of manager and supervisor. Okay. I'm going to read this in yellow. The rest of this stuff, y'all can just pause the video and read. Well, I'm going to read everything from the yellow part on down just to see, because this stuff is new to me too. The purpose of this suit is to give notice for the purposes of establishing a claim upon which relief can be granted. If a lawsuit is filed, you would need the name of the individuals to either prove either negligence, look up how you sue for negligence, or deliberate actions. Look up how you sue for deliberate actions, or any other acts. So what the author is telling you to do in that part is, if you're trying to sue for negligence, then you need to read cases that will explain to you the elements of negligence. Or if you're trying to sue for deliberate actions, then you need to read cases that will explain to you the elements of deliberate actions. All so-called crimes, I don't care what it is, they have elements. These elements are the ingredients. Once you properly allege these elements or these allegations or these ultimate facts, like I've stated in my video, if you do it correctly, then you should get discovery. And what you do with the discovery is you ask for evidence that you need to prove the allegations in your complaint. First, you have to make the allegations. That's essentially what you're doing. All of this stuff is the same, man. It is all the same. Every You are all dealing with administrative agencies. This is administrative procedure. That is all this is. The Constitution is an administrative document of the people, meaning it belongs to the people. And all three branches of government are administering the law of the people. That is what they're doing, y'all. They're all administrative agencies, every last one of them. I don't know. I've never read that anywhere in any case, but I understand what an administrative agency is. They follow procedures. That's what they do. They follow written procedures, and they only do what they are told to do. That's it. And that's what all three branches of government are. They're administrative agencies. Child Support Administrative Agency, Department of Motor Vehicles administrative agency, the city, an administrative agency, a town, an administrative agency, the county, the school board, uh, the fire department, the sheriff's office, the police department. They are all administrative agencies. When your ass go to jail and you get a disciplinary or something like that, and you have a hearing before some sort of administrative board, that is administrative aid. That is administrative procedure. Do y'all understand this? They've taken you from they've taken people from under the jurisdiction of the Constitution and placed them and placed them in a jurisdiction where they are superior, so to speak. But that in that jurisdiction, everything over there is a fiction because you're dealing with corporations. There is no money, and once they start dealing with negotiable instruments, they're no different than a private citizen. That's why anything can be money. That's why, if I'm not mistaken, that's why that they cannot demand you pay you so-called pay them in Federal Reserve notes because they are dealing in negotiable instruments. They ain't no different than a private citizen. So whatever y'all discuss or whatever y'all mutually agree on as money, then that is money. Anyway, just open. I'm trying to just make y'all open up y'all minds and just understand that there is no government. They're all corporations. They are all corporations. They're all corporations. Let's see. This letter is a notice and state open records request to the above state official recipients and a FOIA request to the above federal office official recipients. This is a notice that the undersigned and the individual your agency has deemed, presumed, or alleged to be a customer. I wonder why is that there? Customer. There's got to be a reason that is there. Customer or non-custodial parent is not an absent parent. Let me go and read this again. This is notice that the undersigned, the individual, your agency has deemed, presumed, or alleged to. Okay. So they're saying that you are a customer. A customer to what? Now that's interesting. I wonder what the definition is that they're talking about. Or a non-custodial parent is an absent parent within the meaning of Title 4D Social Security Act, from which your interest arises through delegated powers to regulate the interests of the general welfare. I do not believe your name stated, let me see, your named State Division of Child Support Services inquired whether the undersigned was an absent parent whose child required a welfare assistance by way of your state here, would initially got the title for the agency involved, i.e., by way of your application for services that named that the named custodial parent in the above account filled out. But he must have. Some of this stuff is kind of going over my head a little, but I think I see what the author is trying to do. It seems like that they're trying to get these facts. They're trying to ascertain the facts before an actual lawsuit is actually filed. Because all of them are lawsuits. They filing lawsuits against people. I don't care what it is. It's a lawsuit. Let's see. I'm just scrolling through this right here, y'all. I'm going to go back up because I know y'all didn't see this part. Some of this stuff y'all didn't see. So I'm going to pause that there for maybe 10, 15 seconds and let y'all read it. And then I'm going to go back down. All right, we'll go back down just so y'all can read this stuff. This is for people who didn't send me an email. I'm gonna pause it right there. I'm gonna check some of my emails right now to see if anybody else asked me for a copy of the book. Okay, let's cease and desist. Let's see what they're talking about right here. You are hereby demanded to cease all and any enforcement actions, including but not limited to income or wage deduction, license suspensions, tax offsets, banks freezes, etc., fundamental interests, and infringements. This notice is provided as a courtesy to prevent you from infringing deliberately upon any rights of the undersigned for the lack of your countervailing interests and legitimate government interests. Any continued enforcement before adjudicating in a court of law that the undersigned has one lost parental power without fault of his own, or that the undersigned is or was an absent parent, will constitute violations of my substantial due process protections. Oh, okay. So he's putting them on notice that if they do this shit, he's gonna sue them. And when he does that, she's going to if it comes down to a lawsuit, she's going to attach all of this shit as exhibits, and this is genius. That's pretty good. That is pretty good. You probably can get an equitable judgment against them as well for violating due process to stop them from filing a lawsuit against you for child support in one of these administrative courts, so-called family courts or whatever. This is pretty good. I'm going to start back at number 2. That the undersigned is or was an absent parent will constitute violations of my substantial due process protections, violations of mail fraud, the right to be let alone, that's the Fourth Amendment, the right to privacy, that's the Fourth Amendment, the right to be free from wrongful restraint, that's the Fourth Amendment, right to the fruits of my labor, that's private property, so that is a substantial due process violation. RICO, extortion under the Hobbs Act, right to the enjoyment of business, that's private property. All of these, notice that all of these rights, these rights are private property. Rights are property. I think I told y'all that in another video. Violation of my privacy rights, the right to the pursuit of happiness, the 10th Amendment, the 9th Amendment, including but not limited to infringements upon economic, pecuniary, and property interests. I'm going to have to do an interview with the author of this. And I'm going to I would like for them to come on to the show and where they can, y'all can ask questions and they can substantiate, some of this stuff to explain it to you better. The undersigned requests that respondents immediately determine through a hearing as it was burdened the undersigned to do so, and give notice of such hearing, time, place, and date of whether, as applied to the undersigned, whether he is an absent parent as stated above, and whether parental power has been voluntarily relinquished without fault of the undersigned within 30 days after receipt. So they're trying to resolve this shit before it goes to court. And if they don't hear anything from them, then you can get I think this is where equitable estoppel will come in at. You would file a petition in a court of equity. You would plead these facts to show that you tried to resolve this matter before they filed the lawsuit and they never responded. So as a matter of law, you reasonably believe that you are entitled to a remedy that is exclusively within the jurisdiction of equity, and that in this case would be equitable estoppel. Not to mention that these are 42 Section 1983 violations if they did do that. Although I am not certain if this particular administrative agency is a person within the meaning of 42 Section 1983. But this is a good argument. If you can't sue them, well, you can sue them. You probably wouldn't be able to get so-called money damages for them for violating. You would probably have to sue the agents of that agency in their private capacity. But you could get an equitable relief, meaning like an injunction against them to stop them from doing that in the 42 section 1983 action. You can do all of that in one lawsuit. Let's see. 2. The respondents immediately close this child support account. The undersigned hereby declares not to be subject to restraints not shared by the public generally. See Jones versus Cunningham. Signed, dated, and notarized on the penalty of perjury. Sample with explanations. John Freeman, alienating parent. Okay, looks like a made-up case number. Motion to court to rule on the issue of custody, in this case under strict scrutiny protection as applied to the plaintiff, and constitutional challenge to state statute requiring the use of the best interest standard. Comes now John Freeman giving notice that he is invoking fundamental protections, states that this action involves property rights and rights that require strict scrutiny and paramount protection under the Constitution. I would cite under maybe the 14th Amendment or something like that, of your state and the United States Constitution as applied to the plaintiffs as father and further states as follows. 1. Start off by telling court about the case, date it was filed, who filed, all relevant information. Keep it professional and lawful and written as if a lawyer articulated it. That's true. Then you mentioned the fundamental rights in the case. That's also true. So all of this stuff is the same, y'all. I told y'all all of it. The author is telling you exactly what to do. All of this stuff is the same. You would say on such and such date, this happened. On such and such date, this happened. But you're only talking about everything that is relevant to proving how fundamental rights are at risk or either at issue or at risk of being violated by this agency or something like that. See, 1. Father has fundamental liberties requiring strict scrutiny protection. The reason I would state these rights, these fundamental rights, is because you're going to let the court know that, 1, the so-called court know that you know what you're talking about. So like it'll be patently. Patently means clearly. This is just another word for saying clearly. I'm gonna just say clearly. It'll be clearly evident that they violated due process when you make these allegations and you aver that these fundamental liberties are at issue in this case. If they rule against you. The father in this case has a property right deserving of paramount and strict scrutiny protection in it, that he has a right to the services and labor of his minor child at issue in this case, that he has a right to the upbringing, to the education, to the custody. All of those are fundamental rights, independent of civil rights. They're not civil rights. I mean, they can be made, probably can be made civil rights, but that's irrelevant because they're already fundamental rights. However, remembering from your notes, this right can only exist if the father, 1, has not been given visitation through any faults of his own in a prior court order, and 2, has not yet legitimated his child, and as such, no fundamental rights has yet been adjudicated. For father granted provision, example, okay. They're giving an example. Okay, I'm gonna read that example, and I'm gonna provide y'all some comments on it. Let me see how far we are in the video. 48 minutes. Okay. For fathers granted visitation in any prior orders, example, on June 6, 2016, although the father by court order was granted visitation, it was through no fault of his own. And as such, the father's parental power as it relates to this property interest is intact and deserving of paramount protection under the Constitution and strict scrutiny protection. So he was granted visitation. It was through no fault of his own. What do they mean? That seems kind of a little vague, but I'm gonna see what they're talking about. Number 3, number 3 is alleged because it is a strategy that goes back to the case law reference in Chapter 2, in which it states the father's visitation rights or custody entitled to the other parent deprive the father of custody, thus the right to the services, essentially meaning consequently no child support can be paid because custody and the obligation to maintain a child go together. And if the father was deprived of custody by giving visitation to him through no okay, I see what they're saying now. By giving visitation to him through no fault of his own, he is relieved of the obligation of child support. So even if a court awarded visitation in a prior case to you, the court would now be trapped into either, when ruling on the specific issue, ruling that you did not have a property right to your child's services and labor, meaning now your obligation of support has been terminated in your pending motion to terminate. I'm gonna read that again. Let's see. So even if a court awarded visitation is a prior case to you, the court would now be trapped into either, when ruling on the specific issue, into either, the court would now be trapped into either ruling that you do not have a property right to your child's services and labor, meaning now your obligation of support can be terminated. Okay, I see what they're saying now. In your pending motion to terminate, or you do, or you do, meaning that strict scrutiny protection is now required in this custody case as applied to you. This is genius. This is actually how you stay ahead of them. You got to play chess. And that's exactly what the author is doing. Trust and believe now that an attorney or a court's best course of action to hide the truth will be to outright state that no such right exists to further stall without specifically stating that you do not have the right to your child's services or you have lost the right. When this happens, know that you are on the right path and this book was written for that reason. Be mindful of res judicata when mentioning claims prior to the court order. However, that can only apply if the issues actually determined. However, that can only apply to the issues actually determined. Boy, getting a little dyslexic here, y'all. For fathers granted joint custody or equal protection placement, or equal time placement, or legitimating a child, or asking for custody after a divorce. Example, on June 6, 2006, the father by court order was granted joint custody, and as such, the father's parental power as it relates to this property interest is intact and must be protected under strict scrutiny. Hey, there is no need for strategy here as the married father and legitimating father are deemed to be the fathers of the child at issue, and their property rights to the services and labor of their child have not been adjudicated. Lastly, a father with joint physical custody still has his rights intact as such. His property right to the services of his child are still there. The father parent states the mother father is unfit and has been the deliberate parent who herself alone causes the conflict and has refused to remedy it with the father. We are alleging a fact situation into which fundamental interests cannot be offset or cancel each other out because of only one parent's refusal to co-parent. This is something I need to study, but this is pretty good. The father parent states that he has a right to the educational rearing and religious upbringing of his minor child. We discussed this thoroughly on page 59. The father states that property rights and interests are at stake, in this case requiring strict scrutiny. The father states that privacy rights, let me see. Okay, I already read that one. The father states that he has a pecuniary and economic interest at stake, in this case, in it in it that requiring the father to pay child support in this action without making such a finding that he has failed to pay private maintenance or abandon his child will infringe on these rights. Okay. The father states that these rights are not exhaustive and reserves the right to invoke any other rights in this action. Belief that this court ruled on each of the fundamental liberties mentioned, that this court ruled on the issues in determining whether custody requires strict scrutiny protection or, in the alternative, invoke equity jurisdiction when ruling on issues of custody, that this court make a finding of substantial harm before depriving or diminishing any of the father's rights mentioned, that strict scrutiny displaces the best interests of stand that strict scrutiny displaces the best interest standard as applied to the father, parent, plaintiff in the determination of custody, or in the alternative, that the court invoke equity jurisdiction, that a hearing be set on this motion, or in the alternative, heard and ruled upon before the trial, before the final trial, or has a threshold, or as a threshold issue at the final trial. I need to slow down and stop reading so fast. If I were you, I would, as you will have to do anyway, utilize discovery to prove these claims before the trial. I would not allow the court to rule on this issue without proving my claims in discovery, disposition, or the author tried to put depositions, discovery, depositions, or requests for admissions. I would also reference and create affidavits for this motion to quote for reference throughout this motion, okay, such as the injunction for support only to facts in which I would have firsthand knowledge, because that's the only way that you pretty much can make an affidavit, and you have to be competent to testify. I would also ask the court to rule on this issue before the final hearing. This would give me time to now, if necessary, appeal the denial of this motion before custody issues are determined. Also seeking a stay pending the appeal of this motion, considering the fundamental issues at play. Yeah, that's smart. That's very smart. A stay is when, like, so let's say, and you're in family court or whatever, and you're making constitutional arguments in regards to fundamental rights, and you made a motion and the motion was denied, and you think the motion should have been granted, so you want to file, I think they call it a well, I'm not sure if that's it. That might be an interlocutory appeal. If not, I would say that order that was denied is an appealable order. So you would file a notice of appeal in the court in which they denied your motion, pay the filing fee for the appeal, notice of, and all that stuff. You would also file a motion, either in the trial court, probably not in the trial court. They're probably not going to grant it. You would file a motion to stay those proceedings pending the disposition of your appeal in the court in which you are appealing to. The motion to stay it puts a pause, a halt, or a stop on the proceedings in the court that just denied your motion. So everything stops right there until the issues are disposed of, meaning ruled on in the appellate court, if that makes sense. That's basically what you're doing. Let's see. That this court find the mother's action unfit, and that the father's fundamental rights to the care, custody, and control of his child is intact. Grant any and all other relief just and proper. That's an equitable stating right there. That's an equity stating. It's a general equity statement. See where it says relief just. Equity is just and proper. Depends on what the circumstances are, though. Once this is done successfully, the court cannot take away your parental power, joint custody arrangement, which includes your property rights, and make you a non-custodial parent without utilizing strict scrutiny protection for these fundamental liberties. In addition, the court cannot force a father to pay child support if he is made by judicial decree a non-custodial parent with visitation, because we must recognize that fathers are being plundered for the purposes of creating a revenue stream for Title 4D grants and incentives, and the only way to cease this action is for a substantial number of world citizens to use this knowledge and apply it to their cases as applied to them, specifically meaning one citizen, you, not generally meaning all citizens. Let's see how much more time we got. Where we at? I was on. Okay. Well, we are already at an hour. What page am I on? That was 35. So we're on page 36 right now. So what I'm going to do is I'm going to stop here for today. I'll come back tomorrow with part 5, if I'm not mistaken. And we'll just pick on up where we left off until the ebook is finished. I'm really doing this ebook for pretty much everybody on this channel, and to people who haven't already asked for a copy. If you don't have a copy of it, that's also the purpose of this ebook. But anyway, make sure y'all hit that like and that subscription button. I really appreciate that. And turn that notification bell on. Hopefully this is helping y'all. The Supreme Litigant is out. Peace.